active and aspiring white-collar criminals. Attorney-client privilege is a cornerstone of the legal profession designed to foster open communication between a client and their attorney. However, the protection that attorney-client privilege affords is not absolute and can be affected by the nature of the information disclosed by the client and the type of crime or misconduct involved. Let's explore a couple of scenarios and the legal ethical implications in detail. But first, the fundamentals. Attorney-client privilege protects communications between a lawyer and their client made for the purpose of seeking or providing legal advice. The privilege applies only to confidential communications made for those purposes, which means it does not protect underlying facts, physical evidence, or crimes or frauds that are facilitated or orchestrated by the lawyer. Most jurisdictions recognize specific exceptions to the privilege, particularly under the so-called crime fraud exception, and mandatory reporting rules exist for certain crimes. So you need to understand that the existence of attorney-client privilege is not a magical shield under which you can enlist your lawyer to help you cleverly plot your next wildly illegal scheme. But it also doesn't mean that your lawyer can march to the local sheriff's office and collect a whistleblower reward for reporting you either. Now, to help sort through these nuances, let's discuss a couple of scenarios involving financial crimes and unethical behavior. Let's start with a client who has committed and completed a one-off illegal act, such as willfully lying on his taxes, and he's seeking legal advice on the matter. In this case, communications are generally going to be protected by the attorney-client privilege. The lawyer's role is to provide legal advice, which could include explaining the consequences of tax fraud, assisting the client with rectifying the situation, or defending the client or negotiating a settlement in the event the IRS pursues charges or levies penalties. Now, lawyers are not required to report past crimes, as doing so would violate privilege. However, they cannot actively assist you, the client, in perpetuating or covering up the fraud either. The lawyer may suggest corrective actions, such as amending the falsified tax returns, but the lawyer cannot make these corrections without your consent. If you and your lawyer are deadlocked, that is, if the lawyer urges you to submit a voluntary disclosure to resolve your noncompliance and limit your exposure to criminal prosecution, but you want your lawyer to help you further falsify corporate records to support the fraud, your lawyer might, and in fact probably should, elect to formally withdraw as your counsel. Now, for what it's worth, when there is an intractable ethical divergence between lawyer and client, I consider the lawyer's withdrawal to absolutely be the best case outcome for both parties. And if that happens to you, I'd urge you to accept it with grace and simply seek out a new attorney, probably one who you don't try to involve in your crime. Now, things get more complicated when the client's illegal or unethical acts are ongoing. For example, the case of a Ponzi scheme wherein not only has the client already misappropriated funds, but the scheme has not been identified by a regulatory or police authority yet, and so they are actively continuing to do so through the course of the legal representation. Now, to be very clear, if the client uses the lawyer's advice or representation to continue to commit fraud, the crime fraud exception may apply. Communications related to ongoing criminal activity are not protected by privilege. Now, there can be some gray areas here depending on why the lawyer was engaged to begin with. Obviously, hiring a lawyer to help you make the scam even more lucrative falls into the crime fraud exception. But what if the client wants assistance in promptly terminating the scheme, even if they don't intend to return any stolen funds to the original defrauded investors? If the lawyer can provide advice as to how to terminate the scheme so that no further fraud can be perpetrated, that's great, right? But if part of that process is, at the client's insistence, to move or conceal assets to prevent recovery by the existing victims, then the lawyer's advice might be construed as aiding in a continuing wrongful act, and the crime fraud exception might still apply. Put differently, clients are not legally or ethically required to return stolen funds as a condition for receiving legal advice, but a lawyer advising the client on implementing a termination without restitution might be deemed to have assisted in concealing the crime or shielding assets just as much as delaying disclosures or misrepresenting financial records or creating, dissolving, and moving money between shell corporations would. In some jurisdictions, lawyers may or must withdraw from representation to avoid facilitating the scheme. The line gets blurry quickly, particularly if the only way to terminate the scheme involves further harm to investors or further potential obstruction of justice. Given how tenuous the distinction is between advice, complicity, and active involvement in a cover up, there is a huge variance among lawyers as to whether or not they would even touch a situation like this, no matter how high an hourly rate the client was willing to pay. Now, can your lawyer rat you out? Well, depending on local laws or regulations, sometimes the lawyer may disclose confidential information if necessary to prevent substantial financial harm to others. Disclosure to authorities is typically permitted but not required, except in cases involving mandatory reporting statutes or professional conduct rules. The bottom line is the lawyer must not knowingly assist the client in continuing or concealing the fraudulent activity. Advising the client to stop the scheme is an ethical necessity. Now, this is purely anecdotal, but my suspicion is that most lawyers who aren't the type that will do whatever you ask as long as you pay them enough would probably withdraw from the engagement if they could not competently assist you without perpetuating the underlying fraud, but they also probably would not proactively report you to regulators or police authorities for fear of unintentionally breaking whatever legal privilege continues to adhere. Finally, let's talk about a situation where the client hasn't actually done anything illegal yet, or at least the client hasn't admitted it to the lawyer, but he or she contacts the attorney in connection with the commission of a future crime. Let's say a plan to defraud a business partner and misappropriate company funds into a secret personal account. Under the American Bar Association's model rules, which act as the baseline for many states' adopted rules, a lawyer may disclose information to prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interests of another person. Some jurisdictions require disclosure if the lawyer's services are being used to further that crime. If the lawyer reasonably believes that disclosure is necessary to prevent the crime, they are typically permitted but not required to report it. Lawyers must balance the option to report a prospective crime with their duty to maintain confidentiality and privilege. Now, once again, we quickly get into a gray area. Your average client isn't booking a consultation to say, hey, just checking to see if this is illegal or not. And when you, the lawyer, tell them it is in fact very illegal, they are aghast and enthusiastically agree that they'll abandon the plan. Now, on the flip side, most clients won't be so brazen to acknowledge that they know darn well that the proposed conduct is unlawful, admit that they are enlisting legal counsel because they want help getting away with it, and they inform you that they're going to proceed imminently with or without your help. So, from a practical perspective, lawyers in this situation face the challenge of operating without clear, evidence-based knowledge about their clients' short and long-term intentions, and they need to navigate this ambiguity carefully, balancing the professional duties to the client while also ensuring that they aren't complicit in illegal conduct. So, your lawyer might warn you, the client, of potential legal consequences. They might ask you whether you're seeking advice to ensure that you comply with the law and what steps you're planning to take after the consultation. They might refuse to assist or withdraw representation if they don't like the answers to those questions. And they might report you, but only if the applicable jurisdiction permits or requires it, and even then, only after weighing ethical obligations. Now, again, my anecdotal perspective is that the overwhelming majority of lawyers are going to err on the side of keeping their mouths shut, even if theoretically it would not be an ethical violation to report you, because the perception of betraying client trust and ethical requirements, even for the greater good of sparing your business partners from going bankrupt over your scam, is so severely damaging to the lawyer's reputation. It's kind of a no-win situation. Now, this legal consideration channel is about business, finance, and the law, which is why I focused on white collar property and financial crimes and frauds in this video today. But I'd be remiss if I didn't make it clear that these are distinct from personal injury crimes. For violent crimes like assault, murder, or rape, many jurisdictions require lawyers to disclose confidential information if it could prevent imminent death or serious bodily harm. Financial crimes generally do not trigger mandatory reporting unless they involve ongoing or future substantial harm like widespread financial ruin. Property crimes and financial crimes, while serious, often involve discretionary disclosure unless there is a superseding regulatory requirement, whereas violent crimes are more likely to override privilege due to the immediate risk to life or safety. While attorney-client privilege is robust, it does have its limits, particularly in situations involving future or ongoing crimes, and especially if those crimes are violent in nature. Lawyers must navigate these situations very carefully, balancing confidentiality with their ethical and legal duties. Understanding the nuances between financial and personal injury crimes helps attorneys to act appropriately in their clients' and the public's best interests. If you're concerned, bring up those concerns directly with your attorney. And hey, remember that your best bet is always just to not commit the crimes at all.